Welcome back, everybody, to our studies in the law of contracts. In this lesson, what we're going to do is talk about duress as a method by which a contract may come to an end or be made void. Now, fundamentally, the lesson itself and the next lesson that we're going to look at are going to talk about a number of major doctrines within contract law that relate to this bringing of a contract to an end. The first is the common law doctrine of duress. The second is the equitable doctrine of undue influence. So these are sort of tangentially related to each other in some way, one obviously being a little bit more extreme than the other, this being, of course, duress. But these are both ways in which we can bring a contract to an end. So let's begin with this lesson then, and let's begin with the concept of duress. The concept of duress in contract law, so not duress as a defense in criminal law, for example, although there are similarities between the two, but don't forget, these are two different subjects. But fundamentally, the concept of duress within contract law strikes at the very heart of what it means to enter into a contract in the first place. Remember, if we go all the way back to our very, very, very early lessons on the law of contracts, we noted that one of the key and major elements of a contract is this idea that in order for a contract to be valid, in order for an agreement to be valid, the parties to that agreement ought to enter into that agreement voluntarily. You can't have somebody be forced, threatened, coerced into entering into an agreement, and for that contract to then be legally binding onto them if they then decide that they want to essentially pull out of that agreement or to not adhere to the terms of that agreement. If they weren't voluntarily entering into that agreement in the first place, then there isn't a validity in terms of that contract. There is no validity in relation to the contract that has been created. So these lessons that we're going to look at, where we look at the common law doctrine of duress and the equitable doctrine of undue influence, look at situations and circumstances where there isn't this voluntary entering into an agreement. There is this involuntary agreement that is made where an individual has been coerced or has been subjected to some kind of undue influence or has been threatened into entering into an agreement that they would not otherwise have signed or have agreed to. So, duress essentially may vitiate an agreement that is established between the parties to a contract if one of the parties has acted or been forced to act in a way which is the result of an illegitimate pressure. Then it can be argued that they have acted under a form of duress, and that this would essentially allow that contract to be voided. It would essentially make the contract voidable. So this is quite a broad definition. Essentially, you are acting, if you are have some kind of illegitimate pressure placed upon you to come to a conclusion of a contract, then this then makes the contract voidable. You are able to then void that contract yourself. Obviously, the most common example and the easiest to understand example is the idea of a threat of violence. If you have violence against you, threatened against you, then of course this is a common form of duress within contract law. And we'll examine it briefly here. Essentially, if an individual has forced you into a contract as the result of a threat of violence, then that individual has acted under duress. So if I have an agreement that is in place, I have a contract on a table, and I say, if you do not sign this contract, if you do not agree to the terms of this contract, I'll beat you up. I'll hit you in the face. I'll stab you. Some of these really quite egregious threats of violence. If you then go about and respond to that threat of violence in a way that is essentially is instructive of what I want you to do in the first place, if you then go and sign that contract, you cannot be said to have acted in a way that was freely of your own choice, of your own volition, of your own free will, because otherwise, if if you had acted voluntarily in entering into that contract, I would not have needed to use threats of violence in the first place. It was only because of the violence that I threatened upon you that you entered into this agreement. So if you wouldn't have otherwise entered into this agreement, if it was but for the threat of violence that I essentially instructed upon you, then you would then the contract would not have happened, would it? And so then you would have acted under duress, and therefore the contract may be vitiated. So, generally speaking, in terms of this kind of duress, there are generally two requirements for a contract to be voided. The threat of violence must be of a sufficient level to constitute duress. The impact of the threats of violence had over the person who entered into the contract as well must also be sufficient. So if I said to you, sign the contract or I'll slap you, and let's say I'm 5'2" and this individual is 6'7", okay, then theoretically the impact of that threat of violence isn't particularly strong. So the question of, and as well as this, the threat of violence isn't particularly sufficient. So then at this point you might question whether or not it was truly this quite menial threat of violence from a relatively small, impactful individual that actually was the cause of my entering into this contractual arrangement. You remember, the threat of violence has to be the reason for the entering into the agreement. If it wasn't for the fact that you entered into the agreement, if it wasn't for the fact that there was a threat of violence, you wouldn't have entered into the agreement. That is essentially the point of this, the point of a threat of violence. And I will point you to the case of Barton and Armstrong from 1976. Now, this case looks to examine the nature of a threat to a party and whether or not this would constitute falling into this doctrine of duress. Now, the claimant in this case had been the director of a company. The defendant had been a chairman of the company. Now, the question of duress came when the former chairman of the company had made threats to kill the claimant if he did not purchase a number of shares. The claimant did so and claimed that the contract was void on the basis that it was done under duress. I was threatened, my life had been threatened. He had threatened my life, and as a result of which I entered into this contract. So therefore the contract should be void. It shouldn't have any kind of meaning to it. The court actually concluded that, despite the fact that the claimant did also have other commercial considerations in relation to the purchase of the shares, the threat of violence was substantial in terms of making that decision, and so the contract was therefore rendered voidable. So the court acknowledged the fact that the claimant, having also been threatened, of course, with their life, they threatened to kill them, they did also recognize that there were other reasons that were commercial that would have had benefits to you, that would have also led you to enter into that contract. So, remembering here, the point that essentially that should be noted is that there could be other reasons why you enter into a contract, but if there is a sufficient threat of violence, and that this threat of violence actually impacted your decision, that is what would actually come to the conclusion of whether or not duress takes place in this case. So, obviously, the threat was quite substantial in this case, and it was found on account of the facts of the case that it was this threat of violence that caused the individual to decide to enter into this contract, and so as a result of which you could say that there was a successful claim of duress, even though there were other subsidiary considerations which were commercial in nature that the claimant could have also considered in relation to the purchase of those shares.